in more detail and decide whether there is enough harm.
Do you agree that the test is a rational basis?
Yes.
That would be a test that is a little that is different from the one used by the Court of Appeal.
Exactly. We distance ourselves from the test propounded by the majority of the British Columbia Court of Appeal, and to some extent applied, but I would say with some reluctance, by the Court of Appeal for Ontario. I think it fair to say that Mr. Justice Rosenberg, in speaking for the Court of Appeal for Ontario, was content to apply it, but he was not necessarily in full agreement with it, because, as has already been pointed out by members of the Court, he was somewhat concerned as to whether that was dealing with matters by a court at a level of abstraction that's best left to policymakers. But I ask the Court to bear in mind that the principle that those opposite are advancing doesn't just apply to marijuana, doesn't just apply to CDSA, Controlled Drugs and Substances Act offenses, doesn't just apply to criminal code offenses. It applies and will apply to every offense that is on the books for which there is a possibility of imprisonment. So we're not dealing with the principles of marijuana fundamental justice. We are dealing with, as this Court has said, a basic legal principle that is a foundation or building block for our constitutional democracy. So marijuana, at this point of the discussion, should be put to one side, because what this Court should be engaged in first is a delineation of what the principle of fundamental justice is that applies to review of penal legislation, and then, having set that standard, apply it to the facts in these cases as it relates to marijuana, not the other way around. On page 34 of the factum, I deal with the question of process and onus, and I take great issue with the suggestion that would turn this Court's charter jurisprudence on its head and say now that if there is a penal sanction, the accused who is charged says, "I challenge," and, to use the vernacular, the ball is now in the Crown's court. This Court in Mills, which is referred to in paragraph 86 on page 35, specifically said that is not the case. He or she who challenges bears the burden. So it's not a matter of someone challenging and then saying, "I fulfilled my obligation." They have to establish their challenge. And to give you an example which is not in the factum, under the I always seem to get the title wrong. It's either the Import and Export Permit Control Act or the Export and Import Permit Control Act. There is a list of items that are prohibited from importation. You cannot bring them into Canada. If you do so under that statute, you can be prosecuted. It is a summary conviction or indictable offense, both of which potentially carry a period of incarceration. So liberty interest is engaged. In the 1980s, there was an embargo on goods from South Africa. This was part of a political reaction amongst members of the Commonwealth and others to bring pressure to bear on the then apartheid regime in South Africa. So if a particular South African wine or brandy is my substance of choice, to use the vernacular, and I import a case of South African wine, smuggle it into the country, and I'm apprehended, and I'm charged with violating that statute. Summary conviction, indictable, it doesn't matter. I risk incarceration. On the argument advanced particularly by Mr. Conroy, the Crown will then have to justify and establish some harm with respect to why I should legitimately be denied my wine of choice. There are other wines, particularly where I come from. Perhaps people will say I should be drinking British Columbia wines. But my wine of choice is South African. Right? But at one time, I could go to jail for bringing that in. Now, I think the court can take judicial notice that there was great controversy over whether sanctions were or were not effective. People inside and outside of South Africa, the affected group, right, had differing views on whether those sanctions were worthwhile. Were they doing more harm to the economy and the citizens of South Africa than good? The same was recently said of sanctions against the regime in Iraq. Were they doing much more harm than good? On the theory propounded against me, that ultimately becomes a decision for the court to make. It's not a matter for the executive, it's not a matter for Parliament, it's a matter for the court to make. And in my respectful submission, that would involve a dramatic shift in terms of the constitutional arrangement that operates in this country.
I think, though, Mr. Conroy's position was a little more limited than that. The essential concern was that you were justifying this prohibition reference to certain societal concerns. That was the kind of hard discussed. And he was saying, well, if you're going to move societal concerns from Section 1 into Section 7, maybe the owners should go with it, because you're the people who know what it is you acted on in order to.
But that's not what our Constitution says, and that's not what this court has said.
Well, the court has said in connection with Section 1, yes, it is. The onus is on the government. So what he's saying is that there's an overlap between Section 1 and Section 7 in relation to societal interests.
But Section 1 has been interpreted to provide a mechanism by which the state can justify what has already been established to be a breach of a constitutional right. Mr. Conroy wants the onus placed on the Crown at that earlier level. It would be the equivalent of saying, and I'm looking for an analogy, but in the native fishing area, you know, this court's decision in Sparrow and in the subsequent decisions, okay, the Crown, if it is established that a native fishing right exists, and if it is established that there is a regulation, which is generally the case, interferes with the exercise of that right, the onus in both cases being on he or she who asserts the right, then, under the Sparrow test, it falls to the government to justify the infringement. There is no support in our law for the proposition that simply an allegation of infringement requires a response from the government. An accused does not stand up in a criminal trial and say, the government, the prosecution bears the burden ab initio of showing that this evidence that the Crown wishes to tender against me was not seized in by reason of an unreasonable search conducted in violation of Section 8 of the Charter. Even when that violation is established, the case law with respect to Section 24(2), another constitutional provision, right, puts the burden on the party seeking the remedy to establish that the admission of the evidence would bring the administration of justice into disrepute. So that principle is consistent. You only get to a point where the Crown, or the state, I should say more accurately, is required to justify when there has been a finding of an infringement. Because as I come back to this, Mr. Conroy's thesis basically would lead to a trial. It doesn't matter what the offense is, as long as there's a potential for incarceration. In British Columbia, for example, where notice is usually required, you would stand up and simply say, I have filed a notice challenging this section. And the trial judge would say to Crown Counsel, call your evidence, because it's presumptively in violation of Section 7. That is not the law. And to reach that conclusion, in my respectful submission, this Court would have to reverse the judgment in Mills, decided only a few years ago. Because the point was specifically engaged in Mills. And and the Chief Justice and Mr. Justice Iacobucci, and the excerpt is there in paragraph 86 on page 35 of the respondent's factum, that there is a difference between Section 1 and Section 7. And what Mr. Conroy and the others opposite me wish to do is have the court collapse it. And in my submission, that's clearly contrary to existing and well-established constitutional jurisprudence. With respect to the state's objectives in any event, I'd ask the court just to turn briefly to paragraph 120 on page 47 of the factum. I submit this is a succinct statement of the state's objectives as set out by Mr. Justice Rosenberg in Parker, which was a companion case to Clay. Parker raises different issues because it deals with medical marijuana. We, of course, are dealing with, to some extent, I would categorize it as recreational marijuana. But there's no one has come forward amongst this group of appellants to suggest that they have any medical need for marijuana. It's simply, as perhaps Mr. Malmo-Levine best articulated it, their drug of choice. But what Mr. Justice Rosenberg said in Parker, which I submit is a correct statement, is that in the companion case of Clay, I reviewed at greater length the state's objectives in prohibiting marijuana. First, the state has an interest in protecting against the harmful effects of use of that drugs. Those include bronchopulmonary harm to humans, psychomotor impairment for marijuana use leading to a risk of automobile accidents, and no simple screening device for detection, and that is an important feature as well. Those opposite me say, well, you've got the impaired driving provisions, but the reality is there is no marijuana meter in the same way that there is a breathalyzer. So those cases are much more difficult to investigate and prosecute. Mr. Justice Rosenberg continues, possible precipitation of relapse in persons with schizophrenia, possible negative effects on immune system, possible long-term negative cognitive effects in children whose mothers use marijuana while pregnant, possible long-term negative cognitive effects in long-term users, and some evidence that heavy users may develop a dependency. The other objectives are to satisfy Canada's international treaty obligations and to control the domestic and international trade in illicit drugs. That, in my submission, clearly satisfies a rational basis test. It also satisfies the harm test at whatever level. But in my submission, the harm principle is a subset of what I submit is the appropriate standard for constitutional review, and that's the rational basis test. It may be that the rational basis is founded on harm, but it is not necessarily going to be the case. The rational basis, for example, in the embargo situations, may be the opinion of the international community that something has to be done about an oppressive regime. So it's not harm in the type of harm that was debated in the evidence and in the findings in the courts below in these matters.
Well, I wonder whether that's the way of looking at it, or else what the BC Court of Appeal and the Ontario Court of Appeal have agreed on is that we're dealing with the criminal code, the criminal offense provision. And it seems to me there is a bit of a pecking order in, if you like, being branded a criminal or being branded an unlawful importer of embargoed goods. And it seems to me the focus in the courts below on the harm principle as being necessary for criminal code has that added advantage, it seems, rather than just a rational basis, which could take in things like international relations and so on, and more in a regulatory context as opposed to, because you're not defending the legislation of the embargo on criminal law power.